Okay. At this time, I'd like to call the regularly scheduled meeting of the Plaquemines Parish Council as the sole governing authority of the Plaquemines Port Harbor and Terminal District to order for the August the 25th, 22 meeting at 3 p.m. and the machine is open for roll call.
Dr. Gooey?
Present, yep, here.
They must have changed that one with Corey's.
Let the record reflect that all members are present, and we'd like to welcome Ms. Nancy LaHaye today in her first meeting, who has been sworn in earlier today, and welcome to the board. We look forward to working with you, and if you need any assistance, I'm sure the staff is available, and any council member up here is available to try to help. All right? We'll ask that Ms. LaHaye lead us in the prayer, and Mr. LaFrance lead us in the pledge.
Say a prayer for yourself.
We take this moment to acknowledge Almighty God and thank Him for our beautiful blessings, especially for the parish's natural resources. We pray for all of those who have lost their lives from COVID-19. We pray that the number of COVID cases does not reach pandemic levels again and the world moves forward to a healthy and brighter future. We pray that entering this hurricane season, everyone will get prepared and the season will be a peaceful one. We also pray that we will be spared from all harm and destruction. We pray for the people of Ukraine and that you provide a path to peace and to stop the senseless killings. We pray that this government body, comprised of both council and administration, will always serve our parish with honesty, humility, and equality to all, and for the wisdom to know right from wrong and the courage to do that which is right. Amen.
Amen.
I will pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Thank you for all being here today, and we'll move to item number 2.
Executive session, there are none.
Next item, please.
Status report by the Executive Port Director.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the board. I am Sandy Sanders, Executive Director of Plaquemines Port Harbor and Terminal District. Follows is my Executive Director's report for the reporting period of 12 August to 24 August. The staff would also like to welcome you, Madam LaHaye, to the circus, but you're going to really enjoy it. And we look forward to, we're having her come over to the port next week, where she'll meet the staff and we'll give her a brief. So, welcome.
Thank you.
We received notice that Major General Holland with the United States Army Corps of Engineers in Vicksburg signed off on the approval allowing the local Corps of Engineers district to begin the design process for the Baptiste Collette Dredge project. This project was first presented over 10 years ago, and a signing ceremony is being scheduled before Colonel Murphy leaves the command at the district. As soon as I find out the time, I will let the board know that if y'all want to be on the ceremony. The parish was recently awarded a raised grant for the access road for the new ferry ramp at West Point Allahash. This was a joint effort with the port and the PPG, and the port will pay the matching funds on this grant. Subject to your questions and comments, this concludes my report, Mr. Chairman.
Thank you for the report. Any comments or questions on the report? Ms. Newberry?
Mr. Sanders, what's our match on that grant? Do you know offhand?
The gross grant is 1.02 plus, so the max will be 20%.
20% of that, thank you.
Yes, ma'am.
Okay.
Mr. Bartholomew?
Yes. Is that you speaking in reference to the ramps, or are you speaking of Highway 15?
This is just the access road. The ramps will be a DOTD.
The ramps coming, the existing ramps coming off the highway to go onto the ferry. That's what we're speaking now? When you talk about access road.
No, sir, we're talking just a pure access road from Highway 23 leading up to the ramp.
Oh, West Point Lahad.
Yes, sir.
Okay, see, West Point Lahad, that way I understand where you're coming from.
Yes, sir.
Because we got Point Lahad on the east and west.
Yes.
They're distinctive. All right, thank you, sir.
That conclude your comments, Councilman Blau?
Yes, it's done.
Mr. Blink?
Yeah, sure. Which entity, will it be the parish government, the port, or DOTD that's going to be handling the levee crossing permit for the new ferry ramp on the west bank?
We are, you talking about this grant right here or DOTD's program?
So we're building a new levee crossing on the west side of the river up near the siphon.
Yes, sir.
I imagine there's going to be, just as the B3 relocation has been a really lengthy and complicated.
It's not far from that location, but it is, aside from it, it's on land that the parish owns. So this access road will go from Highway 23 to that ramp.
Yes, sir, I understand that. My question is, which entity is handling the permitting of that task?
For the access road,
For the access road?
PPG has.
Yeah.
All right, thank-
PPG is taking the lead on that. I
Okay,
can
thank you.
Run that to ground and report back to you.
Thanks.
Yes, sir.
Mr. Chairman,
Mr. Bartholomew?
do we have any updates on the bridge, the ramps? From the state standpoint, they were contacted, made any comments in reference to where they are?
We've been in constant contact with Stephen Sibley. And I'd like to do this correctly and invite him to the next meeting and let him give us a in-depth brief.
Yes.
Yes, sir. Can do.
That's it, Mr. Chairman.
So Mr. Sibley will be invited to our next meeting?
I will invite him and let you know, Mr. Chairman, if he can make it or as soon as he can make it, we'll make sure he's on hand.
Thank you. Any further comments on the Executive Director's report? Being none, we'll move to the next item.
Financial report, budget to actual.
Good afternoon. All port commissioners have been provided a 2022 total budget report and a detailed budget report with actual expenditures shown as of July 31st, 2022. Due to the financial report last month for the end of the second quarter, all of those, that report has been posted to the port's website along with the details in regards to that. I will share a couple of highlights regarding our revenues and expenditures. I won't be too long because we had a kind of detailed report last month. In regards to revenues, we currently have 54% of total revenues remaining. Expenses, total personal services, we have 58% of the budget remaining. Total financial services, we have 79% of the budget remaining. Total operating services, we have 65% of the budget remaining. In regards to our revenue, our ferry revenues are about 34% below our targeted budget. In regards to our tariff revenues, we are currently about 4% above projected budget in that revenue category. Some highlights on our expenses. We have 3 subcategories that is currently below our expected budget target of 42% remaining. Those subcategories include operating services and supplies with 29% remaining, rents and leases with 22% remaining, and other charges with 0% remaining. If there are no questions, that concludes my report. I do want to, I mentioned it to Council Member Newberry and Chairman Roussel that in the financial packages I did include, and this will be related to an item a little further down the agenda regarding the B3 relocation, but I did include a summary of charges from 2017 to year to date of today, but I included a summary of those charges for the B3 relocation. You can find those in your financial folder as well. Again, if there are no questions, that concludes my report.
Councilmember Bartholomew?
Yeah, I have a concern about the ferry, the budget for the repairs, because I know it seems as though we're doing a lot, and will we have sufficient money, funds to handle those repairs with the ferries? The ferry, mainly that big ferry been sitting, and we see it's on in the dry dock now. And with that, will that cause an impact on our budget as far as the ferry is concerned?
I know we have did a major repair on the ramps recently. That should be included. The ferry revenue that I mentioned is only in regards to the tolls.
Yes.
I don't see a major issue with our total operating services budget in that category with about 65% remaining. So we will be doing a budget review for 2022 following Labor Day, and in preparation for 2023's budget. We will evaluate where we are, what we have coming for the rest of the year, and then start doing some projections for 23. But again, with 65% of our operating budgets, I'm not seeing much
You're in good shape.
concern. Yeah.
In good shape. Because that's the only main concern I have, because it costs us so much.
Yes, and we are working
so
very hard to get some reimbursements for that maintenance in that, and for the ferry department. As you all know, we ran into some issues with transferring those, not issues, but we ran into some procedures that had to be completed before we can transfer over those funds for the ferry maintenance. So we are working on that. We're doing as much as we can to get those funds over to accommodate for some of those costs.
Thank you very much.
You're welcome.
Councilmember Newberry?
Yeah, back to the ferry revenues. So we budgeted $500,000 for the revenues. So is that number was given to you guys from PPG? Because I see that we've only collected 118 and we already in August.
Yes, when we did the 2022 budget for the ferry department, we did mimic what PPG had in their budgets for the previous year. So we put that in again when we do that review. There may be some adjustments to that, just so that we can have a cleaner budget report and show what it actually is, because it is, with it being currently at 76% remaining, it's a good bit over.
It is, it's significant. Maybe we can kind of
significant.
get the history from PPG before we move forward with the next budget and kind of get an idea if that's normal or not normal, so,
Yeah.
thank you.
The total collections have been down for a long time, so it would be a good idea to review the history. Councilmember, the completion of comments, Ms. Newberry? Councilmember LaFrance?
Yes, since we're on the subject about the ferry, are we up to date on our ferry ramp inspections?
As far as I know of, we are.
Could you please check and make sure?
Yes, sir.
I thank you.
Any further comments on this item? Councilmember Blink? Put the machine,
In the past, who else was handling that? I'll be the guy to reach out to.
Yes, he sent me an email a couple of days ago. They had noticed something on one of the Point hash ramps, but it was just something they wasn't unsure of, and I gave some clarification on. So they did look at the Point hash ramps. I don't know about as far as Bell Chase. And I know the state does inspect them as well. I don't know when that one was done last.
I guess what we're trying to avoid is the closure by the state, as we've had issues in the past.
Correct.
So any preventive measures that we can take to provide an assurance that the state will not close them again, that, we want to do that.
Yes, I guess we'll have to get with Ken and see what his inspection.
Okay. Any further comments on this item? Hearing none, we'll move to the next item.
Bids and advertisements. There are none. Next item, introduction of ordinances and resolutions.
We have one introduction, and and it's for Commissioner Roussel, an ordinance authorizing Sandy Sanders, Executive Director of Plaquemines Port Harbor and Terminal District, to purchase land owned by Robert and Jan Surrency. That's it.
Next item, please.
Ordinances and resolutions on second reading and final passage.
6A1 will be deferred.
6A2, an ordinance authorizing Sandy Sanders, Executive Director of Plaquemines Port Harbor and Terminal District, to purchase land owned by Venice Blue Crab LLC and otherwise to provide with respect thereto. Commissioner Roussel.
Yes, this is a piano key property that we've been pursuing, and I offer an X for a second.
Second.
Second by Councilmember LaFrance. Any comments or questions on this? The appraisals are in, and we're moving forward with this purchase if we have no objection. The machine is open. And the ordinance is adopted 9-0. Next item, please.
6B, a resolution authorizing directing Council Attorney Danny P. Garrett III and Port Attorney Melissa Folse Oob to work in conjunction to file on behalf of the Port Harbor and Terminal District a petition for declaratory judgment in regard to the question of whether the contract between the Plaquemines Port Harbor and Terminal District and Sustainability Partners LLC is public debt that requires approval of the Louisiana State Bond Commission under LRS 39:1410.60 et sec, or whether the provisions of Section 2.6 as modified by Item 9 of the contract serve as a valid non-appropriation clause and otherwise to provide with respect thereto. Commissioner Roussel.
Yes, I offer an X for a second.
Second.
Second by Councilmember LaFrance. Any comments or discussion? Comments or discussion? Ms. Newberry?
I think this should be open for discussion, just so we, this is obviously a judgment against the SP contract, and it's a question I think we all have in mind, is this debt or not debt? I was under the impression that it was a concession agreement. Can one of the attorneys opine to that? And what kind of agreement did we actually approve? So do you have any knowledge of that, Melissa or Danny?
Ms. Newberry, Melissa and I have actually both looked at this. I was here when it was originally confected, but Mr. Rathburn was actually a port attorney who took the lead on it. And that's actually been the question. In summary, a concession agreement is a situation where the private entity generally will go out and construct some sort of infrastructure that has a revenue stream that would affect to it. And in this case, it'd be the rail. And that they would then be paid when third parties pay to use the rail, they would get a percentage of those monies. That's a traditional concessions agreement. The question in this agreement is that there is what is purported to be a non-appropriation clause. Ordinarily, you wouldn't have that in a concessions agreement because there should never be a reason to appropriate money. This agreement is somewhat unique in the sense that the first phase of the agreement, there is an element of the agreement that does have the port paying SP monies. So the question then arises, if the port were to ever not appropriate the money, does that affect a breach on behalf of the port, or do they have that authority? There are two conditions in the non-appropriation clause in the CEA. One that requires that the port act in good faith in attempting to appropriate the money, and the second is that the port treat this appropriation in the same manner as it would treat an appropriation to pay its utilities. And so that's created a question as to whether or not that non-appropriation clause is effective. There's very little jurisprudence on this. There's essentially a seminal case and a line of Attorney General's opinion over about the last 35 years, which seems to indicate that if a document will obligate a public body to make an appropriation of funds in a subsequent fiscal year, then that is a public debt instrument and would have to be approved by the bond commission in order to be effective. However, a way to avoid having to go to the bond commission is by a non-appropriation or a termination for convenience clause. A non-appropriation clause generally being that there's a clause in the contract that says if the public body doesn't want to continue doing it, they simply don't appropriate the money to continue doing what they were doing. And so this was the question that we posed to the Attorney General's office to try to resolve this question. The Attorney General declined
Right.
to answer the question on the grounds that the contract was already signed. Since they responded to us, the Attorney General has also declined to opine both to the Louisiana Legislative Auditor on really what was kind of a hypothetical based upon a number of documents they have reviewed, and the Parish of Lafayette also had a document that they wanted to know whether it was public debt. The Attorney General likewise declined to opine on those documents. They had done it in the past, but this is a policy of the AG's office. So the alternatives are, do you go back and renegotiate the agreement, or if you want to find out what the terms of the agreement as adopted and as executed mean, one option is a declaratory judgment, which is essentially where one party to a contract simply goes to the court and asks for the court to clarify the various parties' rights and responsibilities, so that it's intended to avoid one party having to say, well, this is how I interpret it, so I'm just going to take this action, and then potentially that action being deemed a breach. And so that's one of the options. Like I said, the first option that y'all exercised was to go to the AG and see if the AG, as they had done in the past with other agreements, would simply opine, yes, this is a valid non-appropriation clause, so it's not debt, or this is not a valid non-appropriation clause, therefore it is debt and should have gone to the bond commission.
Wouldn't the state opine on this even if we wouldn't move forward with this? Because if they felt like it was something illegal, I mean, how does that come into play with government when they move forward with contracts versus right and wrong, I guess?
Well, and that's the issue, is that the Attorney General's office declined to opine on that.
Okay.
And again, it wasn't just us. They told us no, they told the legislative auditor no, and they told the Parish of Lafayette no, and they were very similar questions. Now, ours was a specific agreement. Lafayette's was a specific agreement. The legislative auditor proposed a sort of hypothetical agreement that they had put together, and I actually spoke to the general counsel of the legislative auditor today to get clarity on that. They actually put together a hypothetical that of documents that they had seen, and like I said, so I guess the point is to seeking a declaratory judgment is so that the council, acting as governing authority of the port, would know what would be the effect if y'all opted not to appropriate the money. Would it act as a true non-appropriation and that the agreement just terminates? Or would there be some element of damage that would be owed? Because certainly, I think, from my perspective as an attorney for the council, and I think Melissa agrees as the attorney for the port, it's better to know what the likely result of that council action would be than not. That was the only point. And again, we had hoped that the Attorney General would have provided some guidance on that. They simply opted, in their discretion, not to do so.
Well, I'd hate to see this project not come to fruition. I mean, this is a major project for Plaquemines. We're getting really close. We have a lot of stakeholders involved. SP has been really great to deal with. I know in the meetings, they did say that they were willing to negotiate any, if we had some other idea or whatever solution that we can come up with. But obviously, Mr. Roussel still feels like the litigation needs to move forward so we can get a clear picture where we are and how do we move forward. So with this ramification, do you believe we can still move forward with the timeline that we have on the table, or would this possibly stop the project?
Well, I mean, I think if the court were to rule that this non-appropriation clause was not a valid non-appropriation clause, I think that would probably trigger whether or not certain obligations in the contract do amount to public debt that had not yet been approved by the bond commission. Now, that still leaves you two options. One, contract ends, is terminated ab initio, or is just terminated. Or then subsequently go to the bond commission and get the bond commission to sign off on the document. A lot of people don't realize whenever a local public body is going to enter into debt that exceeds a fiscal year, the bond commission, this statutory provision is so the bond commission can look at the agreement and make a determination for themselves whether they believe that the public body will have sufficient revenues to meet its debt obligations under that agreement. Because even though the state is not technically liable for the debts of parishes and cities, as a political matter, oftentimes if a parish or a city were to default on a debt instrument, oftentimes the creditor looks to the state. And so that's why this provision is in the statute. Like I said, there's not a lot of jurisprudence on it. There are a number of attorney general's opinions. There's nothing specifically on this type of non-appropriation clause, which is why we had hoped the AG would have weighed in. They have ruled in other cases, or they have opined in other situations where, for example, there was a circumstance where there was a non-appropriation clause, but it said that if the city in that sense, or if they chose not to appropriate the money, it triggered a penalty provision and they owed at least some money to the creditor beyond what they had already paid for that fiscal year.
Is this local, if this gets approved today, does this local court or does this go to another court?
Because the parish is here, and this is your domicile, because the contract is impacting a project that is within Plaquemines Parish, the appropriate venue is Plaquemines Parish. Just like any other court ruling, there would then potentially be an appeal to the Fourth Circuit, and from there, potentially appeal to the Supreme Court if either party disagreed with that lower court's ruling.
Okay, thank you.
Completed, Councilman Newberry? Councilmember Blink?
Sure. While I didn't vote for the SP contract, when it was being shopped around, I was under the impression that the payment for this rail line would be in the form of a rail usage fee per rail car. It wasn't really established in the meetings what that cost would be. Would you agree with that, Mrs. Newberry?
No, there was no cost established. You're just saying that we had the opportunity to partner with SP and for us to gain, it's a revenue sharing. So however many rails, it was per per car.
Yeah, sure. I mean, I don't personally.
But we didn't have a number. You're correct.
Yeah. I mean, I don't want to share the revenue of the Plaquemines Port Harbor and Terminal District with any third party. But I guess what I was asking, but when we were in those meetings, it seemed like the payment mechanism was a fee that would be associated per rail car or per ton. Would you agree with that, correct? Mm-hmm. And after this contract was executed, it turned out that SP would in fact receive a percentage of total tariffs going to the port. Is that correct too?
Maybe Mr. Ferrari can answer that question. I can't answer that question. I was just under the impression that we were.
Chris, would you mind approaching the microphone and explaining how the payment mechanism would work? Yes.
Hello, everybody.
Just identify yourself and address.
Chris Ferrari, Baton Rouge, Louisiana.
And you represent who?
Sustainability Partners. The specific question again is, just so I make sure I answer it clearly.
Sure. So Plaquemines Parish Port Harbor Terminal District is receiving a rail line financed by your organization in return for what?
It's for a revenue share of the TEUs transported on the rail when the rail's complete and receiving cargo from the terminal.
Got it. All right. So what is the cost per TEU that SP would receive?
I believe there was a schedule of projected funds that was distributed months ago. I don't have it with me today, but we can definitely discuss those specific numbers.
And
We're open to have that conversation for sure.
and SP would own the rail line, correct?
The rail line would be owned by the SPV, which the Port Authority would have sole exclusive rights to.
So SP would own the rail line and receive a fee based
SP
on.
would administer the special purpose vehicle in which the work product and the improvements were made through and funded through, in which the Port Authority has exclusive rights of ownership of improved assets, including the intellectual property and the rail infrastructure itself.
And besides any fees associated with a 20-unit equivalent, what other fees would SP collect to move cargo? For instance, not all the cargo will eventually be containerized, correct, right? There's going to be a new rail line. The rail line would pass the existing coal terminal. There could be coal moved on it. It's going to pass NOLA oil terminal. There could be, crude oil moved in tanker cars on that. What would that look like?
So I guess the intended question is related to potential additional revenues garnered on existing businesses up along the river, not just the terminal itself. So the way that the model works, it's purely based on invested capital into the investment model, meaning that, we set top and bottom collars that's negotiated and can be renegotiated at any point y'all request of what those limits of participation of revenue share can be. And so if the rail line, say, to your point, Mr. Blank, I guess garners a larger revenue than expected, then we could be limited to either the participation level that was approved upon by the board, or we may seek and say, hey, can we participate in a greater deal of the revenue share? Y'all may say no. But that is a decision that this board would have as part of the negotiation on those unrealized or future realized revenues.
Has anybody on this board done enough homework to figure out the cost per TEU that will be moved? Like, what is our fee to SP going to be? This is the mechanism. You stated clearly. What is the fee? What is this port?
I
Sandy,
think
do you
there
have-
is projection, Richie, I don't know if we have them offhand. Sandy, didn't they do the projection on this? We just don't have it in front of us.
The intellectual property was based on not our tariffs, but on our lease.
So are you telling me that the fee is intellectual property, that we cannot know that?
No, I'm talking about what we're paying now was based on our lease, not our tariffs. So what we're paying for right now, okay? And there are figures for what the usage fee would be. It's not per TEU, it would be, I guess, rail car.
Yeah, I could probably clear it up. There's two parts of this agreement. So there is a capital recovery service component, which is the portion of work associated with the production of engineering plans, permitting, entitlements to get it construction ready. That is what we are calling the revenue share portion, which is based off of the overall port revenue from tariffs. Not tariffs, the lease. Well, it's to us, it's just from your revenue collection, right? It's how y'all internally will define what bucket it comes from. That we don't control that. Once the design is done and permitted, which we are completing part 2 of 4 parts, then the full known cost of the improvements would be defined, and then that cost would then determine the exact TEU revenue per TEU allocations back to the SPV. Now, we provided a schedule of projected potential revenues based on projected construction costs from the development team, and that's what's been used as kind of a basis of understanding to the amount of TEUs that we anticipate receiving on the rail, and then projected cost per TEU for usage of that rail. Again, I don't have that schedule of values with me today, but it's been distributed before, and we're more than happy to pull it up and meet. And again, that exact financial revenue share coming in on the TEUs would be a final negotiation determined at the point in which the costs are known for the construction.
Quite the unconventional way of doing business, huh? All right, I yield, thank you.
Councilmember Kanovich.
Someone on this commission voted to borrow the 8 million, right?
Excuse me?
We borrowed 8 million.
I wouldn't say, I don't know, I didn't borrow anything.
Well, what are we paying, LA 23 and for the design and engineering and all? We didn't get 8 million from y'all?
But no, it's, you're not paying the LA 23.
They getting the money and they're
So-
paying somebody.
An SPV was created, which is, again, a special purpose vehicle. It's a sole entity designed to collect investment funds from our capital providers and partners. And out of that SPV, contracts were issued to a development company, LA 23, under an MGSA contract. That contract is made with that SPV. So when we put money into the SPV, it's only at the pre-approval of this board, and then we allocate certain restricted amount of funds for a certain restricted amount of defined scope of work. Once that work is completed, we evaluate that completion of work with monthly pay applications, and, Jake from our team is here who monitors that activity. And, the next phase of work is not allowed to proceed unless this board approves that phase as well. The fees that are being paid directly into that SPV now is to maintain the intellectual rights use of the property created into the SPV, meaning design plans, permits, et cetera.
That's just a bunch of words saying that we getting 8 million from you at different intervals to pay for that design, engineering and all that.
Yeah.
Each step we got to vote on. And then you give it to LA 23 and they do what they want to do.
So just like you vote on the steps throughout the design process, there's a final vote prior to converting the completed design work and permitting into a construction project. So if the first phase is completed and the board elects to not proceed with construction, want to negotiate, renegotiate our deal, anybody else's deal, which you can still do at any point, it's up to this committee or board to elect to move into the next phase.
That's what I said. Each step we got to vote on. Up to 8 million, then we see how much it's going to cost to build the rail, and we have to vote on that. Get the money from y'all.
If you elect to get the money from us. Yeah.
Any point that we vote no, we're not going to do it, who's going to pay the money?
Well, at this stage, a few options would be, I don't know if an outside party would want to come in and take over the project. If you would want us to help procure bonds or other means of monies to help transfer that ownership of information. It's really up to y'all's decision on how you would want to proceed. We can proceed in how we've been currently contracted. We can discuss alternatives on how to renegotiate the contract. We can help you get a bond if that's the way that you want to go. We can restructure the current contract to become a debt contract now. We're willing to do all that at our expense.
But if we voted on the next step of building it, no containers come, who pays for it?
So that would be, say we build it and no containers come. Well, that's a different model because we'd be in our infrastructure as a service, business model at that point. And so we would likely have to come and negotiate what those adjusted payments, if any, if none, if there's other opportunities to accept, to Mr. Blank's point, additional, commerce amongst existing businesses, which I think was part of an earlier analysis when we looked at the rail to begin with, as opportunity outside of the terminal itself. We would have to negotiate what that looks like. I mean, it's
But you want your $58 million back.
under that model, I could probably reserve that for Mr. Kane and Adam Kane, but under that model, it's that is a more liberal negotiated piece, because it's a different business model than what the, CRS model, which is what we're in now, is technically contracted for.
Let's say we paid a 58 million. If we wanted to own the rail, we got to buy it from you.
If you wanted to own it, like say you wanted to buy it from us the day after it finished, right? Like how would you have done that previously, right? You would have had to.
We could have went and got bonds on our own.
Extended. What's that?
We could have got bonds on our own.
You can get, well, I don't know. I don't know y'all's, appetite for bonds and which I've done in the past. It's theoretically, you can go get a bond and you can do it yourself. If you have a private company approach the port and say, look, y'all have done the engineering, you get the permits, we'll take SP, out of the deal and we'll build it ourselves, then that's something that we're okay with as well. I mean, it's really comes down to the approach that y'all want to take to get the job completed and move forward. We have, I believe we met with a handful of y'all over the last 2 days. There are avenues in which we can come to an agreement with the different terms of a contract if there's time to sit down and do it and we're willing to give the time.
I'm done.
Any further comments from the board? Any further comments from the audience? Councilman Gui.
Well, I actually have some comments.
Chris, yeah, if you'd stay up and anyone in the audience may be able to help too. Shifting gears a little bit, you know that, and I think everyone in the audience is somewhat aware of this, that our beneficial, our BCO, our beneficial cargo owner, is on a timeline. And they have to deliver their product at such and such a time. And that's the timeline that we're working on. One of the requirements they presented to us was we need rail. And hence, we're here today, and SP has negotiated a contract with us to provide the rail, build the rail, maintain the rail, and have a usage agreement so that the port would be able to generate some revenues once the trains start rolling. Because of that timeline, have you discussed with anyone the potential delay time that if we go to court, what would be the delay time approximate as opposed to maybe some other alternatives? And I'd like you to answer, if you can, delay time with a deck action, even though it's here, it's right upstairs. Any thoughts of you or even Mr. Garrett or Ms. Oob, anyone? Go with you first.
I'll do the best I can to answer that question. When you get into, litigation items, you never really know how quick and long it happens, depending on how much people really want to fight. I mean, it's kind of, they take a life of themselves, basically.
But this is for a deck action, I assume a deck action is something that's a little quicker.
I don't know.
Less discovery and.
Personally, I've never been affiliated or associated
All right.
with the deck action, so it's hard for me to personally answer that question. I don't know how fast or how long they happen. I imagine if rulings are in disfavor of either party, it could extend quite some time.
Yeah, I think it's an important thing to at least get a ballpark on, because the competition that we're facing to get the container port is real, and the timeline is real. And if we do something that will delay the timeline to where the project is no longer manageable, then we have a problem. So I'm opening it up to anyone who can give me a.
May I speak to that?
Yes, sir.
Good afternoon. My name is Gray Sexton. I'm an attorney. I represent Sustainability Partners. We appeal to you to give further consideration to the filing of any lawsuit that would have the immediate effect of completely derailing this project. The timeline for resolution of a suit for declaratory judgment is on the order of 2 years. The law requires the joinder of all parties who are going to be affected by a declaratory judgment. That would include our major financial institutions. We've already received indications that APM, Angelica, Vulsars, and the other major shipping industries are going to be paralyzed by the impact of the filing of a lawsuit to derail the efficacy of the contract that was previously entered into. That contract, the contract between the port and Sustainability Partners, was entered into only after it was carefully reviewed by the legislative auditor, by the general counsel for the legislative auditor, by skilled attorneys representing this port, by attorneys representing the parish government. Every aspect of it was given the most prudent consideration. Sustainability partners, its financial institutions that have backed this project, its engineering firms, will be placed at risk as the result of the filing of this suit. But more importantly, this project will come to a grinding halt. No one is going to spend any more money. No one is going to invest any more capital if a suit for declaratory judgment is filed that on the order of 2 years will take to resolve, and that will ultimately entail joining all of the parties that are going to be affected by this lawsuit. The resolution that I read suggests that the bond commission should be invited to make a determination as to whether or not this contract should be approved by the bond commission. You don't need a lawsuit to do that. Send the contract over to the bonding commission. Write a letter, transmit it, the contract to the bonding commission. Let the bonding commission do whatever it is that this particular port commission might seek to achieve. That might not have an immediate impact of completely derailing this project. It's a complicating factor, but one that we're prepared to live with. But the filing of a lawsuit will occasion significant expense to the port. It will entail extensive litigation. There will be depositions. There will be motions for the production of documents. There will be scheduling orders. And in the event a decision is rendered that's not satisfactory to the port, I have every reason to believe it will seek appellate review. And I'm certain that in the event a decision is rendered that's not satisfactory to SP's partners, to its financial institutions, to its engineering and design firms, I'm almost certain there'll be the appellate review of that decision by a district court. All I see is time and money. And in the meantime, this project is going to sit on the sidelines. In a broader sense, if the port does not want to build this project, someone else is. Either it will be built with private funds, or tax base will be created, and the port will access its tax base through the sale of bonds, which basically is a form of taxation, or the port will be built somewhere else. We're talking about one of the largest infrastructures ever built in South Louisiana. This would be a world-class facility. It is designed to be one of the best, one of the most modern, and perhaps one of the most expensive container ship ports in the world. It would interject an enormous amount of energy, capital, passion, goodwill, and employment to this parish. I appeal to you that that is the risk that would be taken if a lawsuit is filed against sustainability partners that then results in the enjoining of half a dozen financial institutions, architectural firms, engineering firms, planning firms, all of whom are going to be affected by the outcome of that lawsuit. We have not seen the lawsuit. But according to the resolution, that lawsuit is to seek some sort of judicial determination over the validity of a contract that was entered into in good faith by the port and by sustainability and by the parish government. Nothing good's going to come of that, and a lot of evil is going to result from derailing this project that could be the best thing that's ever happened to the port of Plaquemines.
Thank you for your comments.
Let me, thank you, sir. I'd asked others about the timing it would take to settle this, and I was given anywhere from 1 to 2 months. So that's the information I was given, and you did mention that there are other avenues that would be acceptable to SP, and that was one of the subsequent questions I had, is that what else can we do to settle it? And I think you've answered that. There are other alternatives through state agencies. And you've also answered a question I was going to ask as to, not that we haven't been told this, we've been told, repetitively told pretty much the same stuff about the contract and the research that went in preparing the contract. the use of the legislative auditors, the previous contracts you've had, not only in the state of Louisiana, but throughout the nation, which was similar to what we approved here at this board. To me, the bottom line is, I'm going to repeat this port is in competition. And I didn't think about what you said with the private sector, the public sector, but with other ports. And their eyeballs are on us. And that competition is something we need to be very wary of. And I did want to know, and you answered it appropriately, that some delays would occur. And those delays, depending on what they are, could be a work stoppage. And that work stoppage then affects our BCO, who is on a timeline, to get the rail done so that they can deliver their products from here to their, the contracts, fulfill the contracts they have in the Caribbean. So I appreciate what you have to say. I was aware of the legislative auditor's review, the attorney's review, our attorney's review, the parish government's attorney's review, your review, and that we approved it. And now we're 40, 50% into it, and we're starting to make some changes. So the concern I have is everything I've just expressed, but mainly the delay of the project having the potential of killing the project. So I appreciate your comments, and I yield the floor.
Complete, Councilman Good. Councilman Blank, do you want the floor again?
Yeah, certainly. Mr. Sexton, I really appreciate you zealously representing your client, right? And up here, we have to zealously represent the public, right? And it's what we've been selected for. The SP contract passed, it was a 5-3 vote, is that correct? 5-3 votes.
Something like that.
So, yeah, it was a split decision here. We weren't exactly rowing in the same direction on this, that we thought it was the best idea about how to finance this critical piece of infrastructure. And I've had a lot of heartburn because there's been no concessions by SP or the port or even my colleagues who voted for it to make sure there's concessions for existing highway traffic here. There's existing businesses, there's existing residents. And furthermore, if y'all are in the business of loaning money, instead of loaning us $50 million, why not loan us $80 million so we could build some railroad overpasses so we don't have to deal with all of the delays. If this port is as good as you just said it is, this place is going to be a transportation nightmare. Belle Chase will become unlivable. There will be two halves to it. You know, you said a lot of good things. It's going to be transformative, world class. It's going to be one of the biggest ports around. How are we going to shoehorn 100,000 containers a year through Belle Chase? I don't know how we're going to do it. I don't know how. Stuart, do you have some ideas?
I think that, may I?
Yeah, please.
I think that those involved with the rail are well aware of the impacts that are going to occur.
But do they care?
And
Let me
Wait.
point of order here. We're getting into the weeds here.
Yeah.
You know, we are addressing a declaratory judgment action, and I would appreciate if we can try to stick to the issue. Any further board members? If not, you want to say something, Mr. Konovich? I'm sorry, you.
While we go out for this declaratory judgment, nobody has to stop work.
Well, I'd imagine if it goes into a declaratory judgment, misfiling action against our contract and the validity of our presence, I can't imagine that further funds would be invested to proceed with the project.
But until it is judged on,
Well,
judge
so
comes
the-
back with it,
Yeah, so
no
the
work
board-
has to be stopped.
The only person who has authority to approve payment
Push your
requests
hand, Nancy.
under the current approval of the allotted funds allowed to spend is the port
Nancy
administrator.
wants to speak.
And then this body would have to approve the next allotment of funds to go into phase 3. So
When does that come?
I think it comes, you know, when,
All right.
maybe in a few months, I think towards the end of the year. So it's, but yeah, so we're not allowed to invest more dollars unless this board approves us to do so.
All right, you've completed, Councilman
Come
Blank?
till December,
Comment?
months come before December. If the judgment takes 2 months.
You complete, Councilman Konovich? Councilman LaHaye?
I just have a question. I've heard 2 months, 2 years? Is it 2 months or 2 years for a declaratory judgment? That's a big difference.
Councilman,
Yeah, I'm talking
Mr.
to
Garrett.
Mr. Garrett.
Again, in all due respect to Mr. Sexton, we've known each other a long time. How long it takes does depend on how the parties approach it. If the parties approach the declaratory judgment that, look, and simply ask the court, look at the language in the document. Does the language in the document create is that a public debt instrument? If so, the statute's extremely clear that it would have to be approved by the bond commission to be binding. If the language in the non-appropriation clause with the conditions set forth in there does not impair that non-appropriation clause, then the law is extremely clear that with a non-appropriation clause, it would not be a debt instrument and would not require approval of the bond commission. Now, that result would be that if the parish or if the port would ever desire not to appropriate money to move into a subsequent fiscal year, that there would be no penalty. And SP would be totally within their rights simply to step away from the project. So, and the question, I think, is that narrow. I think it could become much broader, but it would depend I can tell you, I would not anticipate having to do depositions if the question I'm putting to the court on your behalf is asking the court to interpret the four corners of the document. So I think it actually could be done very quickly. I've had declaratory judgments in the past that were just that. Everybody agrees on the facts. Everybody agrees that this is the document. Simply ask the court, what is the effect of these words under the law? Now, granted, one side or the other might not like what the court rules and may want to take that to the Court of Appeal. But again, I think if you were talking about a situation where the council took an action that SP believed was a breach and then there was a lawsuit, yeah, I think that would take a lot more time because it's much more adversarial. I would think that you could get this done in a matter of a few months if everybody was intent on doing that. But certainly, parties have the ability to do as much discovery as they want and make it last as long as they want. I would respectfully disagree that parties who are not a party to this contract would necessarily have to be a party. I think that in a declaratory judgment action, I think if all of the parties to the contract are parties to the suit, that's all that's required. Now, you may have other interested parties who may want to seek amicus status and who may want to ask the court, can they file a memo too? But I would disagree that you would have to name everyone who is tangentially affected by the contract. I think because the obligations in the contract solely are between the Plaquemines Port Harbor and Terminal District and SP.
I do have a clarification. I got a note of clarification of when the next, allotment of phase for funds to be approved, and it would be the end of September, not in December.
All right, let's move on. Any further comments, Mr. LaHaye? Thank you for your comments. I'm going to make a couple of comments. This issue has been tried to be clarified for quite some time. This board passed a resolution seeking an Attorney General's opinion to try to clarify this. Your representatives went to the Attorney General's office and led in interference and met with the Attorney General to present your case. Therefore, we have no opinion. Now, I've seen legislation passed, or at least in the legislature, to deal with this type of issue, to bring these P3s to the bond commission, and y'all have fought those efforts, and you killed the bill. So there's really no effort here to try to get to the heart of what I'm trying to get to, whether or not this is debt. And that's the bottom line. And the reason I believe that this is debt is because every nickel that SP gives to LA 23 and pays it, this board, according to the contract, has to pay it back to SP. And if there are not enough rail cars on the rail to pay that note, then it has to come out of its general fund to make up the difference. So I'm going to leave it at that and ask anybody else in the audience, if you have any comments, please come up. Y'all, we thank you for your comments. We're moving to the audience now, that if anybody else would like to come forward.
Reverend Tyrone Nesbitt, 112 Thomas Lane. Benny, can you explain this to the general public in terms of what the parish government is involved in with this in everyday language where people can understand it, why we have to be in court with a contract that relates to the Pope? What is the issue that's trying to be resolved that everybody can understand it? In simple language, we can understand how did we get to this process and why we need a court order.
Well, we are trying to determine whether or not this board is in debt to Sustainability Partners for up to $6 million at this point. We know that this board approved forwarding funds through SP. We know that SP's contract does not make them liable for any of the deliverables, the quantity, the quality, or any of that. They have admitted that time and time again. However, into the contract, it's my understanding that the deliverables are supposed to be owned by this board. Now, the deliverables are engineerings, drawings, studies, all of those things that it would take to get to a bid process. Now, my heartburn has been, and I've been told over and over by SP and LA 23, that the contract between those two entities is a private contract. And we are not privy to seeing any of those expenditures in detail. And so I don't think that we should be sitting here putting money into a project that we don't know where the money is gone to start with. The second part, however, is the debt aspect of it. There are penalties for doing things like this. And, you know, if you don't follow the law, which I don't know that we followed them, let me just read you this one little section here that gives me a little heartburn about not getting debt approved by the bond commission. It says any person, and this is 1410.63, penalties for violation of what I believe we have violated. Any person or any officer, agent, or employee of any governmental agency named in RS 39:1410.60 who violates this part, or who counsels, aids, or abets the violation thereof, or who participates with others who attempts to engage in the borrowing or lending of, or any attempt to borrow or lend any money, the calling of any election, the incurring of any debt, the issuing of negotiation or sale of any bond, or other evidence of debt whatsoever, the levying of any tax, the mortgaging of any land, building, machinery, equipment, or the pledge of any tax, income, or revenues without the consent and approval first and obtained of the commission shall be fined not less than $100, not more than $500, and imprisoned for not more than 6 months. And I'm in a position here to where I personally believe that if I borrow money, and they're saying it's not borrowing because they're using these terms, but if I get them to put money up to a project, and I have to vote, as you heard, we have to vote to let that money go, to pay those notes, which the notes come out of the port funds to make that note. And as of December, we might be paying $70,000 a month on this note. I believe that if someone gives money and they require a repayment with interest, that it is a debt. No matter how you structure it, no matter how many fancy lawyers you get up there to twist it and spin it, I believe that it's a debt. Now, we have tried to get this answer through the Attorney General's office, which there were efforts to block that. We are now trying to get it through a declaratory judgment. When we asked the Attorney General for an opinion, it was a unanimous vote. Because the people up here said, yeah, we got to find out if we got a debt. Well, now, because of the lobbying efforts of those involved, we've got a different spin. And I agree with Dr. Gouy. We'd like to see this project built, but we're not even close to it. We've got partners that have bailed out on us because we don't have the property purchased that we are building, and I hate to quote Fauché, to rail to nowhere, because we have no project in the works to build this rail to. But putting all of that aside, if they want to buy a 2-year lawsuit and fight us for 2 years, that's where we will be. If they want to go and get the answer a couple of months, 3 months, that's where we will be. But every effort that I have seen is to delay, delay, delay. And to come back and say you're going to want another $2 million in September, with still the same scenario of no transparency, no way of knowing where the money's gone, is beyond me. And when you put that phrase to me about we want to help, we want to see what we can do, that's massaging a problem that won't go away. And I'm here today to try to fix that problem with a declaratory judgment to find out where we are.
Lastly, Mr. Roussel, I've heard you use the term I, the pronoun I, and then I heard you use the pronoun we. And so it's a question for me to understand, when it's we and not I on the council, because it seems like to me there is a division on the council as it relates to the Pope, and we just didn't get into the decision overnight. I'm not questioning the attorney in this matter, but if we got an attorney that really understands if had the position you was in, then we should have never signed that agreement. So the question is, the agreement was signed, how did we get to the level? If it's we, if it's really a we council, then how did the we council put us in this position? That's the question, where the parity government is strapped for cash right now, and we're in this dilemma. So it just bothers my mind how we get to this level.
By a 5-4 vote. That's how we got here. Any further comments on the question here? None? Machine is open. Call a question.
He had wanted to get up.
Oh, is it more of the same?
Well, we have a prepared statement from themselves.
You want to read it into the record for the lawsuit? Is that what you want to do? Well, what is the intent? Because we've heard your story for a long time, many times. Do you have anything new to add other than the document that, or the record that you want to build for the court for the lawsuit? What's that?
Can you go to the mic?
Yeah, go to the mic. You go to the mic, and its opinion of fact is the same opinion of fact you're going to answer the lawsuit with, and save us all a lot of time.
Look, I'm not an attorney. I don't know what goes in a lawsuit or what doesn't go in a lawsuit.
But who prepared it for you?
Prepared.
Who prepared the statement for you?
That's sustainability partners themselves and myself together.
No lawyer.
Well,
No legal help with that statement.
well, Mr. Kane was present. Adam Kane is the corporate attorney.
So the attorney did a prayer. Go ahead.
So I'm able to read it in.
Yeah, read it in for the record, because I'm sure we'll see it in the court filing.
Thank you. Appreciate it. SP is the country's first and only private entity with the legal requirement to be a long-term partner with government to assist their essential infrastructure. SP is technically classified as a public benefit company that is written into the Articles of Incorporation of Sustainability Partners. We believe that the proposed resolution is not going to achieve what is really desired by some members of the board. This type of lawsuit results in the involvement of all affected parties. These major companies will hire national law firms demanding comprehensive discovery and expert testimony. They will insist all work stop, as the purpose of the declaratory judgment is not determining the nature of the agreement, but really to set a foundation to see if the port can have taken the millions of dollars for work the port approved and have an angle to try and not pay it back. Obviously, this is likely to be the end of the rail and a terminal project with respect to any Plaquemines Port involvement. Firms like APM, ourselves, and Delusion Volker and others will stay clear of further development and involvement after litigation of this scale. The characterization of the suit as being fast and low cost is, in our opinion, simply wrong. It will take major port funding in the hundreds of thousands of dollars, plus major distraction of all port staff and port council members. Such a budget and effort would be material to the port, and we do not understand why it is better for the port to use taxpayer money for this when other non-litigious options are available in free state resources with specific jurisdiction of these types if questions are available. Earlier today, we learned that the purpose of the proposed resolution is to address wanting to know not just the allocated amounts of the costs of the deliverables, but the exact amounts of each subcontractor has received to date. If we would have known this prior to the project starting, this would have been a requirement specific to the project addendum that the Port Council approved. We are here to assist in any way we can, so although there is not a legal right to the information from the project addendum, we would like the opportunity of a few weeks to use our influence on these subcontractors to obtain the information and try to create an effort of collaboration and trust. SP has proceeded at every step in good faith with the port, and these facts are as follows. Prior to entering into the agreement, both parish and port council reviewed the contract. In this agreement, the port represented to SP that the agreement is valid, binding, and enforceable, and that the agreement was duly authorized for execution and performance in accordance with applicable laws and with any articles, charter, or organizational documents or authorities applicable to the port. As part of the port's good faith in entering the agreement with SP, the port involved the Legislative Auditor's Office, which determined how government transactions are financially represented. The 4 legislative auditors involved expressed no concern and recommended no changes to the agreement. To our knowledge, the auditors made no representation to the transaction should be treated as debt and thus needed to be approved by the Bond Commission. These auditors from the state were Jennifer Shea, Angela Heath, Mike Wagasback, and Roger Harris. In addition to it being in the scope of the legislative auditor, we believe the agreement conforms to GASB 60 concession, and as such, the accounting with the agreement would be consistent with that. However, SP is willing to redo the agreement at no additional cost to convert the transaction to debt if the port elects to do so. Had the legislative auditor expressed the agreement actually being debt, certainly the port and parish attorneys would have recommended the port to submit the Bond Commission for approval. We have always been comfortable with submitting the agreement to the Bond Commission for approval, and we would still support that decision today if elected to. Making the actual submittal is something that we can't technically do, but would have to come from the port itself. With respect to the non-appropriation clause, changes to the non-appropriation clause were specifically requested and implemented at the direction from the port's legal counsel. Furthermore, the port and SP already agreed in section 25 of the agreement that if any clause in the agreement is to be found invalid, the rest of the agreement still holds true. SP has followed the agreement and provided the funds per the agreement at the port's direction, timing, and approval. Because the project is ongoing and the port has confirmed and approved the distributions under that agreement, we believe for this reason and many other reasons that there is zero chance that the port will not be responsible for these costs. SP will, of course, do everything it can to minimize such legal expenses and time involved, but realize that legal action takes time and it can take a life of its own. We believe that at this time that SP and the port have been acting in good faith to this point, and any concern can be resolved by continuing to be good faith with each other. Again, our request is for you to allow us some time to obtain the specific payments that have been made to each subcontractor prior to filing any litigation. And for you to do so, consider using free expert state resources like the state auditors, whose primary role and jurisdiction is to assure that Louisiana public entities are correctly reporting their transactions versus litigation. Appreciate you.
Thank you, thank you. Is there going to be a repeat of what you already said?
1 minute. Not verifying anything that we previously said. We did meet with the Attorney General, and our understanding was that the Attorney General's opinion was that these issues were sorted out on the front end of the contract, and therefore it would be inappropriate for the Attorney General to comment on the validity of a contract that had been entered into in good faith between the council and sustainability partners. And Mr. Russell, you're a very experienced and capable politician, and I know that you recognize that important decisions are often made by divided votes. Perhaps the most important decisions ever made by the United States Congress, by the Louisiana Legislature, and certainly by this Port Commission are made after serious debate, after their exchange of competing ideas, but after a vote is taken, that then becomes the law of the land. And it's important that contractors be allowed to rely on contracts that have been entered into by governmental agencies. If contracts are not reliable, financial institutions, contractors, engineers, architects, and designers will think long and hard before they enter into a contract if the other side is not going to uphold their bargain. The issue involving whether or not this contract required bond approval was a subject of robust debate, discussion, examination by everyone involved prior to the time the vote was taken that led to the implementation of this contract. To attempt to revisit that issue now will likely put an end to this project. If this port doesn't build this container depot, someone else will. It's a multi-billion-dollar opportunity for the port. If that opportunity is passed up, then someone else will capture that opportunity. And I appeal to you to recognize that the filing of a lawsuit will have a terrifying effect on everyone involved on our side. Financial institutions will withdraw their support. The container industry will withdraw its commitments.
Now, you're getting to repeat what we've already heard. And look, I appreciate your expertise and your legalese, and I've watched you many years. But the fact is that the Attorney General's office did not want to opine on this because of the fact that this will send ripples throughout the state on P3s. The legislative order did not give you approval on this contract. They reviewed it. There's a big distinction there. And I know Jennifer Shane was on the phone with her yesterday. And so they actually asked for an opinion as well. So let's not confuse the issue, okay? And just as you stated, that if we are going to have a democratic system, let's vote, and we'll see what the law of the land is today. Thank you for your comments, and I call the question. And the item is approved 6-3. Thank you, and that's the law of the land today. Next item, please.
Item 6C, a resolution authorizing Maynard Sandy Sanders as Executive Director of the Plaquemines Port, Harbor, and Terminal District to enter into a consulting agreement with the Ladder and Bloom Holding LLC and otherwise to provide with respect thereto. Commissioner Roussel.
I so offer to ask for a second.
Commissioner Roussel, I wanted to remind you that we have some changes in the contract.
Please read the changes.
Sure. In the first paragraph where it's identifying the parties, the name has been changed as Ladder and Bloom's representative is Carl Landreneau, Director of Commercial. And then at the end of the contract where the parties sign, the name has changed there also with Carl Landreneau. Carl Landreneau.
Yes, as I ask for a second. Second by Mr. Konovich. As you know, that the individual that we had working on this contract has since passed, and the rates have been reduced to reflect the new individual that we have working on this project. And I must say that the new individuals that are working on this contract are doing a pretty good job of moving forward with trying to acquire these piano keys. And we've stepped up the pace considerably this year compared to the years of the past. So I ask for your support on this item. If you have any questions, the administration is here and I'm here. If not, machine is open. Yes. Let the reflect that 9-0, item passes. We move to item D, please.
Item D, an ordinance to amend the 5-year capital improvement plan, D3 relocation project, and otherwise to provide with respect thereto. Commissioner Roussel.
So offered. Next for a second. Second by Councilman Gui or Arbro? Or neither one? I heard somebody. Gui, Councilman Gui. Yes, I don't know if the administration wants to opine on this, but what this is the appropriation of the funding to construct the B3 project that is required to be relocated for Venture Global to move forward with their project. As you heard at the last meeting, the attorneys say that if we can hurry up and get this out of the way, we'll be able to collect an extra $8 million a year in rental. And this project has been held up way too long, for years, and it's time to move it forward, and this is the appropriation to allow the bid to go out for the relocation of Port Ship Services. Any comments or questions? Hearing none, machine is open. Yes. And the item is adopted 8-1 with Mr. Blink voting no. Next item, please.
Item E, a resolution establishing a policy of the Plaquemines Port Harbor and Terminal District that ferry tolls shall be collected by deposit in a collection receptacle without any of the ferry department employees being required to handle the money and otherwise to provide with respect thereto. Commissioner Bartholomew.
Councilman Bartholomew.
I'd like to offer with the changes.
Okay. The changes will be at the end of the current, be it resolved, the current second be it resolved. At the end of the paragraph, we are adding and to authorize a port employee excluding deckhands to remove the payments deposited by the public from the secure receptacle.
Mr. Bartholomew offers, is there a second? Second by Dr. Gui. Any comments or questions on the item? Yes, sir.
What's the point of using this receptacle other than so the public can see that we're putting money into a secured box?
Councilman Bartholomew, you want to address it on me?
We purchased that box for the purpose of the money being deposited and it's secured and no money changing hands. And it's staying in the box itself, and the one that the port decides to handle it will have a key at the end of the day to take the money and count it and deposit wherever they see fit, where it goes. And that means the more times, the least amount of time the money is changed, the more accurate account you'll have. And when it's out, the box has already been paid for, and it's going to have to be implemented. And that's the reason for it.
Because I was under the understanding that it was brought to this resolution was so they can drop the math part off of the civil service test so we can get more deckhands.
It's consideration. Nothing will be dropped. It's consideration, and that never was a part of this resolution. But the intent was to make it simplified as much as possible to get this done. Now, the key is that we need deckhands, and this one way is an opportunity. If the if civil service does that, give us more opportunity to get more people eligible for the position. And right now, we in a date straight of getting it done, and that's one way to simplify this process.
I don't think dropping the math part off of that test is going to help us any, because that math part is needed. These deckhands have to count how many cars are coming on the vessel. They have to count how many passengers is in these cars. It's part of a Coast Guard requirement. If there is an accident on that vessel,
So let me ask you this question. You want to address it?
I'm finished with that. That's what I have.
So let me ask you this. So you think that we are hiring deckhands that do not know how to count?
No, I never said that.
Well, that's what we're trying to get to the bottom of. Do you think that we're hiring deckhands that can't distinguish between $1 and a $5 bill?
I'm not sure. It could be a possibility. I'm not sure.
Okay. In my personal opinion, I don't know anybody in this United States that doesn't know how to count their money, whether it's a 10-year-old or a 30-year-old. The point, I believe, is what we're trying to do is, I don't know what the math test is on the civil service exam,
Neither
but
do I.
we have been told that we can't hire deckhands because they can't pass the math test. And when I've heard that discussion, it boggles my mind that I don't know what the math test is, if it's calculus or it's division or whatever it is, but I believe that there are people out there that can throw a rope and count a dollar. And we need to get to that level to be able to hire people so we can run the ferries. And I think that's Mr. Bartholomew's effort here. And as far as the boxes were purchased a long time ago because the public came to us in numbers saying, we don't like to see the deckhand put the money in his pocket. And we understand that.
I'm not opposing the boxes.
Okay, you're opposing what?
I'm opposing what was originally stated, that dropping the math was part of the reason why he wanted the boxes.
No.
That's what I was told last time we came.
I didn't tell you that. My whole, Mr. Chairman, may I?
Go, Councilman Bartholomew, you have the floor.
Yeah. State Civil Service does not require examination for that position. Again, the State Civil Service does not require an exam for that position. Are we that much better than the state to require something that they don't require?
That's not a question for me to answer. That
I'm just telling you the proper procedure. This is another issue why we're trying to eliminate that problem. We want to try to follow the lead of the State Civil Service. That's all I'm saying. And you question whether or not they can count cards. And, I mean, everybody you hire going to be able to count a card. And not all that, you give them clicks anyway, don't you?
Yeah, they have a clicker too.
Well,
Maybe.
I mean, it's very obvious that to eliminate the problem and to expedite employees as much as possible, find the simplest way to do that. And this is the simplest way to get opportunity to consider the employees. To consider. And you all have that determination of considering. That's all, Mr. Chairman.
I don't get the applications. Ms. Lambert gets them first. Then we get them after she vets them.
Well, that means in your department?
I'm
Dr. Gouy?
She's in your department?
Dr. Goui's recognized
Civil
next.
service.
Yeah, but she sent them to you. She sent them to you.
Gets them first.
So you're not getting no more 3 employees to choose from?
Is your mic on?
Oh, okay. When they changed that, I'm not aware. Because all in the future they had where you had 3 numbers. But you can always disagree, right? You always can disagree, can't you?
What I'm trying.
I'm asking the question, and you always disagree to who they send you.
Yes.
All right.
But what I am trying to say is that if all 9 of y'all apply, she gets them first, she runs through them, figures out who qualifies. Then y'all must take a test if y'all qualify. Once you take the test, you pass whatever test they have to take, I get what she qualified.
We realize that.
Well, that's what I'm trying to say. I don't care if 10 people apply. I'm not getting those 10.
We understand that, and the effort here is to try to knock down some walls that she has to get you more applicants.
Yeah, I don't mind making it easier. You know, I kind of feel that we need a good quality employee as well.
Well, you're going to make the final judgment.
Correct.
Dr. Gouy.
Are you sorry Joey left? No. Well, I do have a question, and I think it's a very important question, is are people who want to cross the ferry going to have exact change? And if they don't, are they not allowed to cross on the ferry?
Well, you either give me $5 and go on your way, or you turn around and go get $1.
That's a problem.
That's going to be a problem. And my crew and myself are going to have to deal with that.
Okay.
I don't know, I mean.
But we do have to have, the public needs to know if you don't have a dollar bill or quarters, that then this is what you have to do. And I don't know the answer.
It's going to be a learning curve, just like when you go to Chalmette Ferry. You learn quick if you got to drop $5 in the box and you can't get any change. The next time you go there, you're going to put $1 or you're going to bring the right change. So it will be a learning curve, no doubt. But, Mr. Edwards.
I'm glad we're getting the box, not because of the reason the gentleman's saying, but I'm tired of for years trying to say that ferry is broke because those dedicated deckhands who pay it, being underpaid and not appreciating is the reason why the ferry don't have it there, because they're pocketing money like these guys getting rich. I'm just tired of hearing that they're being accused of that. I use the Shelby Ferry, they got a sign that state that, there's nothing rocket scientist about that. You go to toll booths and all the kind of, there's a system in place. I'm only glad that we're doing it. So now they can't put the financial problem that the deckhands who's so dedicated, who are really not getting what they deserve. And so I'm glad to see that's one less thing that these dedicated deckhands don't have to have on them.
Dr. Gui.
And if this does pass, I think it behooves us to have a start date when it starts, and that we have signage, big signage, so that someone's not waiting in line and then having to get to the front of the line and have to turn around and go back, that the signage, if it's put in the appropriate place, that person will know, oop, I need to go get some change. So I think that's an administrative thing that has to be done on your end, but I yield.
We have installed signs just as of 2-3 weeks ago, large signs, exact change and what the fees are. And if
They're up?
Yes, they are.
I missed it.
No.
Well.
You got to pay, Doc.
Yeah.
Any further comments on this item?
Yes. Yes.
Who? Yes, Mr. Blank?
Sure. With only $500,000 budgeted for ferry tolls annually, and we're at 34% of what should be the annual collection at this point in time, it probably makes sense just to get rid of the tolls altogether. It just seems like a giant pain.
And, that's a possibility, but then you'll invite all of the ferry routers on the next ferry to come down here, and it blocks out the local residents from getting on the ferry. And we've had that experience in the past where, we thought about this, and once you get the free ferry, then our constituents are stuck in the back of the line complaining that the Chalmette people are ahead of them getting on the free ferry. Because they are. Exactly. So it's a catch-22, because I agree. The amount of money that we collect probably is not worth the effort, but it's a deterrent for people to come over here. It's just my experience. Okay? Any more questions on this item?
I got one.
Oh, Mr. Conovich, sorry.
So if I get in line and say I only have a 20, can I say the next 19 cars get to go?
If you want to pay their way? Yeah, why not? Huh?
You're not running for re-election, how about you?
If I got a ride that's going in, the next 19 cars are getting on.
All right. Any further comments on this item?
I'm gonna let my cousin know we missed it.
Cabo rides? All right. The machine is open. Move on.
Yeah. I say something like that.
And the adoption is 7-2 with Ms. LaHaye and Mr.
She didn't vote because
Mine was on the wrong.
Okay. 9-0 then? Doc, you voted for that?
No, mine is on
That's the wrong-
6D.
Ms. LaHaye, did you vote for that?
It's on the wrong, we're on the 6D, it's on 6D instead
Right,
of 6.
but did she vote for that?
I apologize. I didn't.
It's on 6.
I'm just trying to find out if she voted for it so we can move on. Did you vote for that?
6D.
Mr. LaHaye?
There we go. 6D.
Do you want me to open it again,
Okay,
Councilman?
yes.
Commissioner Roussel?
All right.
Commissioners LaHaye and Arbro and LaFrance, we're voting again.
Ms. LaHaye, we're voting again, Ms. LaHaye,
Okay, so now we will vote again. Okay.
for the correct one this time.
Dr. Guliu, yes. 9-0, and the item is passed. Next item, please.
Number 7, new business. 7A, introduction of resolutions wherein suspension is sought. There are none. B, comments by Tim Slotch regarding port public meetings. Commissioner Newberry.
Yes, Tim has a comment. He'd like to make a statement to the board. Tim Schatz is with Waste Pro.
Welcome, Mr. Schatz.
Good afternoon, Chairman Roussel, Port Commissioners, Port Executive Director Sanders, and valued port staff. My name is Tim Schatz. I'm the manager of Riverside Recycling and Disposal and the 2020 chairman of the Plaquemines Association of Business and Industry. My address is 11266 Highway 23, Belle Chase. I want to thank the Plaquemines Port Harbor and Terminal District and Port Commissioners for sponsoring and LA23 Development for presenting at the community meeting last August 2nd at the Belchase Auditorium. That was the second of two meetings. Hopefully there are some more meetings. I found them very, very interesting. LA23 Development Company provided a detailed and easy-to-understand description of the mainland rail extension and the Plaquemines, Louisiana Gateway Terminal project. After his presentation, I recall general support of these projects and don't recall any public opposition. I understand the pending need, I should say I better understand the pending need for expanded shipping container transport to major cities and markets along the Mississippi River and via the Class I railroads that intersect southern Louisiana. I also understand and believe Plaquemines Port Harbor and Terminal District is superior to the congested Port of Mobile, congested Port of New Orleans, and the conceptual container port in Violet. After rereading the executive summary of the Port Development Master Plan, it is now clear to me that these two projects follow the road to success that's described in the Port Development Master Plan. As a young man, my father always reminded me that more is lost by indecision than the wrong decision, and that indecision can be the thief of opportunity. These comments have nothing to do with the actions earlier today. I made these comments 2 weeks ago. But indecision appears to be growing among the Commission. Indecision appears to be growing among American Patriot Holdings, among Andalusian Energy. Mistrust of LA Development Company also appears to be growing. This indecision and mistrust may shadow the port with possible debt from the design of the mainline rail extension and ultimate killing of the mainline rail extension project. We heard about that earlier. Therefore, what I'm respectively urging this commission to do is act as a unified body and proactively and enthusiastically support the mainline rail extension project and Louisiana Gateway Terminal project by directly meeting with American Patriot Holdings and directly meeting with Andalusian Energy. It seems like those two projects control whether or not the mainline rail extension makes sense. And as a layperson in the audience, as a layperson that's gone to the public meetings, I'm sure I'm not the only one that doesn't understand why we can't get a yes or no, a yay or nay from these two major stakeholders. If they gave a yay, then everything's simple. It all falls into place and the mainland rail project makes sense because now you have the revenue to pay for everything. And again, you're looking at me because I know you know more than I do. As a layperson, I'm confused why, if this is a superior project compared to Violet, compared to the Port of New Orleans, why these two companies aren't jumping on and saying, build the railroad. It doesn't make sense to me. So I'm asking this commission to be a little more proactive. I don't know why LA23 isn't proactive. Maybe they are proactive, but I'm asking this commission to be a little more proactive to answer this question because I'm stumped as to why this project is not moving forward and why we don't have, if the railroad is built, why we don't have a solid answer as to why there's not going to be rail car revenue. I appreciate the time to meet with you. Again, your port meetings, I found them very helpful. They've raised more questions and interest. I can't be the only one out there that wants to know more as to why this isn't moving forward at lightning speed. Thank you.
Thank you, Mr. Schatz, for your comments. You want to address them?
Go ahead.
Mr. Schatz, I can give you 2 words of why we have some dilemma here. Trust, transparency.
Thank you, Tim, very much.
Next item, please.
Item 8, approval of the August 11th, 2022 regular meeting minutes.
Offer.
Second.
Been offered by Councilman Bathalamy, second by Councilman LaFrance. Any comments or discussion on the adoption of the minutes? Hearing none, machine is open. And the minutes are adopted 9-0. Any further business to come before the board?
Motion to adjourn.
A motion by Councilmember LaFrance and Councilman Albrow to adjourn. Machine is open.
Request, fix my machine.
And the Port Authority meeting is adjourned at 4:39.